Hello everyone, I'm Emily Forrest and today I will be presenting on school speech, specifically in public schools and when school speech involves social media. So I'm going to start out my presentation today by giving you an outline of what I'll be talking about. I'm first going to start with an introduction to the topic where I'll explain school speech and then I'll move further into explaining why that topic is specifically important for our discussion of creative media law. And then after that, I'm going to talk about the cases. The first case that I'm going to talk about, I have two for you. The first one that I'm going to talk about is Tinker versus Des Moines School District. This case happened in 1969, and it is a precedent case for a lot of other school speech cases. And then we'll move into cases that talk specifically about school speech when it's online and off campus. So that will be in the second case that I talk about, which is Layshawk versus Hermitage School District. That is an example of a case that used the Tinker decision to influence the decision of this case. And then for each of the cases that I talk about, I'm going to provide an overview section where I include just the facts of the case and explain what happened, and then I'll include a relevant section after that where I'm going to talk about why that case is important for our discussion of school speech. And then following that, I will talk about the implications. I'll provide an implication section where I basically conclude what this means for the future of school speech and social media online speech. So getting into the topic at hand, which is school speech in public schools, it's important to understand why I talk specifically about public schools. So public school students possess a wide range of free expression rights under the First Amendment. So students can speak, write articles, assemble to form groups, and even petition school officials on issues that they disagree with. And it's important to note that there is a fundamental distinction between public and private school students under the First Amendment. So the First Amendment and the other provisions under the Bill of Rights limit the government from infringing on an individual's rights. So public school officials act as part of the government, and they are therefore called state actors. And as such, they must act according to the principles established in the Bill of Rights and the Constitution. Private schools, on the other hand, are not affiliated with the state, and so students do not have the same protection of the First Amendment. Though public schools do have the protection of the First Amendment, there are limitations on this protection. So that means under certain circumstances, the school may interfere with a student's speech if necessary. Alright, so now we're going to get into our discussion of the first case, which is Tinker versus Des Moines Independent Community School District, which occurred in 1969. This case is arguably the most important case for this issue because the Tinker decision remains a frequently cited Supreme Court precedent, and this decision is important to understand in the context of other social media cases because it helps us understand the free speech principles in schools and how those principles function in off-campus online student speech. So getting into the facts of the case, this case took place during the Vietnam War in 1965 when siblings John Tinker, Mary Beth Tinker, and another student named Christopher Eggert, who are the plaintiffs of our case, they protested the Vietnam War by wearing black armbands to their school with a peace symbol on the side. To their Des Moines school in Ohio in December of 1965. So Tinker and the other students were suspended by the Des Moines Independent Community School District, which is the defendant of the case. The students and their parents filed suit in federal district court, where they argued that the suspension was a violation of their First Amendment right to freedom of speech. The district court ruled in favor of the school district, and a tie vote in the Court of Appeals permitted the district court's ruling to stand. Tinker then appealed the decision to the United States Supreme Court. So before Tinker, the Supreme Court had not articulated a clear test or a set of rules to determine when students had the ability to engage in freedom of expression. So that's why this case is so important, because it was the first case to actually provide a boundary or a set of rules to help lower courts make that decision. So in this case, the court did establish the rule, which is that students did not shed their First Amendment rights to freedom of speech when they enter school property. And in order to justify a suppression of speech, the school officials have to be able to prove that the conduct in question or the speech in question would materially and substantially interfere with the overall operation of the school. So in this particular incident, it was decided that the wearing of armbands to protest the Vietnam War indicated pure speech, which implicates all of the protection of the First Amendment. And the school officials attempted to punish Tinker for a silent and passive expression of opinion that was not accompanied by any disturbance to the work of the schools. And then in order for the school officials to justify a prohibition, they have to show that that prohibition was based on more than just a desire to avoid the discomfort that usually accompanies an unpopular viewpoint. And in this incident, there is no evidence that the school officials had any reason to anticipate that the wearing of armbands would disturb the school functions. Not to mention, school officials also didn't impose this equally on the students. So some other students were allowed to wear other types of religious or political symbols, such as wearing a necklace with a cross on it, but only the students wearing the black armbands were suspended for expressing that viewpoint, which is in violation of the First Amendment. Okay, so now that we've talked about the precedent case, now we can move into a case involving social media. So this case is one of the many examples of how courts have applied the Tinker decision to modern-day social media speech cases involving students. This case exemplifies the current uncertainty regarding the extent of protected student speech on the internet. This uncertainty has actually frustrated a lot of members of the legal community because a lot of them feel that the student freedom of speech issues are much in need of review by the Supreme Court because the lower courts are struggling to apply the pre-internet frameworks that were laid down in the late 1960s, such as the Tinker decision. And according to Anthony G. Sanchez, who was on the council for the Hermitage School District in this Layshock case, he says that it is time for the Supreme Court to rule on the scope of the First Amendment rights in the situations where students have used the internet to direct off-campus speech toward a school community. This case highlights that the Tinker decision could face a lot more redefinition as social media adds another dimension to these First Amendment questions. Okay, so going into the facts of this case, Justin Layshock, who is featured at the bottom, who you can't really see right now, but he's a student at a high school who created a fake online profile of his high school principal, Eric Trosh, who is in the upper right-hand corner. He created this profile from his home using a personal computer, and Layshock made the profile accessible to other students at the school. The profile included a picture of Trosh and described him as, just to brief you, there is offensive language here, he described him as a thief, an alcoholic, a drug abuser, and a big whore and big fag. So yeah, pretty offensive. Layshock accessed this profile while at school and showed it to other classmates. Trosh discovered the profile and attempted to have the school's IT department restrict access to the website. They did not immediately block the website from students. However, school officials controlled students' access to computers by limiting the settings, so internet access could be supervised. So Layshock was then given a 10-day suspension. He was sent to an alternative education program for 1 semester, And he was also banned from all extracurricular activities, and he was even banned from participating in his own graduation ceremony. Leshock then sued the Hermitage School District, and he claimed that this was in violation of his rights under the First Amendment. The trial court determined that the district could not establish that Leshock's speech caused substantial disruption. So the district appealed to the United States Court of Appeals for the Third Circuit. Alright, I've included a picture of the profile to give you more detail and into the language that was used in this fake profile. So all of Justin's answers were surrounding a theme based on the word big, because Trosh is apparently a large man given the fact that he was a former firefighter, so he was making fun of his muscular stature. And some examples of these questions and answers from the survey I've included on the right. Some of them were not included in the picture. I'm not going to read these answers due to the offensive language and stuff I don't want to say. And while I admit that just based on the word big, these are clever answers because that's hard to do, I can definitely understand the plaintiff's gripe about the profile. So under the interest section, Justin listed transgender appreciators of alcoholic beverages, and Justin also listed Steroids International as a club that Trosh belonged to. Justin made this profile accessible to other students by listing them as friends on the MySpace website, which allowed them to view the profile. And not surprisingly, word of the profile, according to Trosh, spread like wildfire and soon reached most, if not all, of the high school student body. So now thinking about how they applied Tinker to this decision, just to remind you of what the Tinker decision stated, the Supreme Court emphasized that student speech, which for any reason materially disrupts classwork or involves substantial disorder, or invasion of the rights of others, is not immunized by the constitutional guarantee of freedom of speech. And it also states that if there are facts which might reasonably have led school authorities to forecast substantial disruption, that can also result in disciplinary measures. So given those statements, the applicability of Tinker here seems straightforward, although it gives no shelter to the defendant of this case, which is the school district, because as the court opinion notes, quote, the Hermitage School District does not now challenge the finding that the student's conduct did not result in any substantial disruption, nor did the school district show that the student's speech created a reasonable apprehension of substantial disruption. So as a result of this, the district cannot punish Leshock for engaging in this protected speech. Okay, now getting into the nitty-gritty topic of this presentation, which is whether Tinker applies to off-campus online speech. That is the big question that is surrounding a lot of these cases today, which haven't even reached the Supreme Court. So to unpack this, when student expression originates on the physical premises of the school campus, there is no question that Tinker is applicable. Likewise, when student speech occurs away from the school and does not reach campus in any meaningful way, there is little doubt that the full strength of the First Amendment should apply, so teachers cannot punish a student for that. When student speech originates off campus, but ultimately affects the school environment in a substantial disruptive way, the analysis becomes a lot more unclear. The Supreme Court has not yet dealt with a case involving off-campus online speech. So, in the absence of clear Supreme Court guidance, the lower circuits have almost uniformly held that the Tinker decision can be applied to speech originating off-campus. However, there is still a lot of confusion when it comes to making decisions in the lower courts based on the Tinker decision. For instance, Judge Smith argues that with the exceptions of speech specifically directed at the school and of speech while at school-sanctioned events, speech that takes place off campus is beyond the reach of school discipline. So unless it specifically attacks the school, he's saying that we should not, as school officials, discipline the student. Judge Fisher concludes that the, quote, heavy focus in the concurrence on an off-campus versus on-campus distinction is artificial and untenable in the world we live in today. He argues that the reason for this is because all the wireless internet access, smartphones, and social networking services, all those communications give an omnipresence to speech. So in essence, it's everywhere. And so this on-campus versus off-campus decision shouldn't really be a factor that they're considering, is what he argues. So he argues that this omnipresence makes any effort to trace First Amendment boundaries along the physical boundaries of a school campus a recipe for serious problems in our public schools. So he's saying that we need to reevaluate this decision. So again, you can see that there is a lot of uncertainty regarding how this decision should be applied in cases that involve off-campus online speech. For the case that we recently talked about in the Leshock case, the defendant argued that because the speech reached the school and because it was accessed on school premises, that this can be treated as on-campus speech. However, the court determined that just because the speech reached the school, that it originated off campus, so they can't treat it as on-campus speech. And in the situation where he accessed it on school grounds, they had no concrete proof that Justin did in fact do this. So again, that case really highlights this uncertainty of whether on-campus versus off-campus speech should be evaluated with Tinker. So, in conclusion, ultimately, the answer to the question of whether schools can validly regulate student speech when it takes place on social media outside of school remains unclear. The courts do recognize that a dangerous precedent could be set by allowing schools to regulate student speech at home, but have found that schools do have some interest in regulating speech if a substantial disruption will be caused of it. So while the platform of MySpace is relatively obsolete, if you will, the issue has only grown as other social media platforms grow. The Leshock case was just one of many cases dealing with off-campus speech, and there are many other cases that are inconsistent with the application of the Tinker decision. This problem will continue to happen if the landmark decision is not reevaluated. So that's basically what it comes down to, is that this project and these cases that I've included really highlight that the Supreme Court needs to rethink this decision and maybe take on a case that involves off-campus online speech. So that is all I have for you today, and thank you for watching. I hope you enjoyed.